maximization of the value and other one is resolution. Now, just in order to bridge a proper gap, right now the creditors, and this is a creditor revenge process. So ultimately the creditors are having a liberty that they may initiate, and this is what we can say out of the conclusion derived by the latest Supreme Court judgment, that the personal guarantor will not be considered free out of the approved resolution plan, and the action may be initiated against the same. Anyways, we are moving ahead with the same process. So Lalit Kumar Jain judgment, we are just bringing out the conclusion out of it. And this is, the apex court held that the personal guarantor is not ipso facto discharged if the plan is passed. As this court has decided, the sanction of the plan and the finality conferred by it, Section 31 does not function as a discharge of the guarantor's liability. An involuntary procedure, such as by operation of law or owing to liquidation or insolvency, does not absolve the surety or guarantor of their duty arising. Absolutely, in case of liquidation, I fully agree that the liability of guarantor can never comes to an end. Just because of the corporate debtor is into liquidation, personal guarantor should not. So this is not a point of controversy. The point of controversy only exists up to the date when the corporate debtor resolution plan is being approved. Otherwise, if the corporate debtor is dragging into the liquidation, in that case, the creditor to have all the benefits to take something out of the guarantee which was extended by the guarantor. The resolution plan on its approval would then become binding on the corporate debtor, member, guarantor, and also other stakeholder involved in the resolution plan. The court held that the object of the code was to make sure that the personal guarantor will not able to evade their liability once plan is approved. And yes, if, and again, I'm having a contrary views, and I back that the guarantor should be held liable, because if the guarantor will not be held liable just because of the approval of the resolution plan, there will be many fictitious application, or there will be many application which will be moved voluntarily just in order to avoid the consequences on the guarantor. But again, the only point where I am not feeling so satisfied is the guarantor is not getting the benefit of extending guarantee. So this is going to happen that now directors will not be freely giving the guarantee the way they were extending their guarantee in favor of the secured creditor up till now, because guarantors are not getting the benefit which a guarantor should take in the capacity of creditor.
Yeah, I agree.
This is what provided in the last para. This is going to affect the right of third party who is not a part of the contract, as it would not allow him to file for subrogation right under 140 of the Indian Contract Act. Because if I have given a guarantee, I'm not getting my right as a guarantor. The moment I will be trapped into insolvency, I will be having no manner in which I can recover from the corporate debtor in whose favor the guarantee is extended. So this would affect the right of third party, that is a guarantor, who is not a part of the contract, as it would not allow him to file for subrogation right under 140. The judgment given by the court in Lalit Kumar in this case will ensure a deep in the number of defaults by the personal guarantor, because the judgment, it would also make it challenging to find a personal guarantor for a business, and this is going to happen. So personal guarantor will never get their right as a personal guarantor, but their liability shall stay, or it will remain even after the approval of the plan of the corporate debtor. So this will not encourage giving guarantee on behalf of a corporate debtor.
Actually, normally, as per the bank's practice, if all the directors have to give the guarantee when you are taking a board, that's normal.
Absolutely.
That's normal. They have no choice.
But yes, nowadays the guarantee agreements are casually, up till this date, it was casually being extended. It was casually being signed. When we see part 3 of the code, part 3 of the code has mentioned about some excluded assets. Excluded asset. Yes. So even though the insolvency application is initiated against the personal guarantor, but that is not going to hamper those assets. But the value which is provided in the rules are very tiny, as if I don't know how much benefit one can avail by getting that definition of excluded asset. Anyways, that is going to be taken care of when we will be dealing with part 3 of the code. But at this moment, I'm going to take care of the recent judgment of Supreme Court, which was passed on November 9, 2023. So multiple writ petitions were made before the Supreme Court, including the petition made by the Anil Ambani. And this is all about the constitutional validity of section 95 to section 100, that it does not give an opportunity to a debtor to present his case, and directly the appointment of RP is being made. So this is something which was again settled by the Honorable Supreme Court in this judgment of Dilip B. Jivrajka versus Union of India. Now, as far as this Supreme Court judgment is concerned, now this is again coming out of the Lalit Kumar judgment, as Lalit Kumar Jain judgment has cleared the air that personal guarantor will not remain immune upon approval of the resolution plan, and their liability will survive even after the liability of the corporate debtor comes to an end by the purview of approval of resolution plan. So I'm coming to the latest judgment of the Supreme Court up till this date with regards to Dilip B. Jivrajka versus Union of India. And after this judgment, so whatever were, so up till, so Supreme Court has given a stay. Up till the date this judgment was decided, this matter was decided upon, there was stay to all section 94-95 application. But now that 94-95 application for which there was a stay, now the stay is lifted because of the clearance of this judgment, and now the things are rolling. Section 94-95 applications are rolling in a same manner as if earlier section 9 applications were being made when threshold default was rupees 1 lakh. So nowadays one may find out of the cause list that there are multiple section 95 applications which are being made by the secured creditor after getting this clearance from Supreme Court. The constitutional validity of the provisions pertaining to the personal guarantor. So the dispute was not settled. The Lalit Kumar Jain dispute was not settled even after the judgment was passed in the month of May. Yeah, immediately, correct. Supreme Court has made that Lalit Kumar judgment more powerful by passing this judgment. So yeah, the constitutional validity of the provisions pertaining to the personal guarantor in part 3 of the code were recently challenged in series of 384 writ petitions under Article 32 of the Constitution of India. Again, the validity, the whereas of section 95 to 100 of the code was challenged inter alia on the grounds that they are volatile of the principle of natural justice, on the grounds that a personal guarantor was allegedly condemned under unheard and unfettered power, including adjudicatory power, was vested in the RP. I would like to share one more circular which was recently passed on 12th of Feb. I'm going to share with you in very short time. On 9th of November 2023, while a common judgment delivered in the case of Dilip B. Jivrajka versus Union of India, the Supreme Court upheld the constitutional validity of impugned provisions of the code and dismissed all the writ petitions. Three moot points were: do the debtor and the personal guarantor have right to know the grounds or accepting or rejecting insolvency application under section 95? Section 95 talks about an application initiated by the creditor against the personal guarantor. So what happened when section 95 application is made? Section 95 application can be made either itself by the creditor or else through the resolution professional also such application can be made. There is no concept like interim resolution professional, but there is a concept known as interim moratorium. So we are going to deal with that. So basically Supreme Court was dealing with these three law points. Point number one, Do the debtor and the personal guarantor have a right to know the grounds for accepting or rejecting an insolvency application made under 95? That is one point. That is based on Article 14 of the Constitution of India. Second is with regards to Section 96. Does an order of interim moratorium by RP amounts to an arbitrary exercise of power? Third is, does the submission of RP's report under 99? So RP has to frame a report whether the application should be admitted or not. So does the submission of the RP's report under section 99 of the code without providing a copy to the debtor and a personal guarantor violate the principle of natural justice? And Supreme Court has made a very clear judgment, and this is quite convincing also. Now let us have a look on this. The impact of personal guarantee in relation to a corporate debtor undergoing CIRP has raised interesting legal issues. Personal guarantee refer to a promise made by an individual to assume responsibility for repayment of debt in event that the borrower fails to fulfill its obligation to the creditor. Now, this is the recent judgment of Supreme Court, which has settled the ambiguity surrounding the liability of the personal guarantor. Nevertheless, certain issues remain unaddressed. Following the Insolvency and Bankruptcy Second Amendment 2018, which we were discussing, 15th November 19, that notification, the personal guarantors are directly subjected to insolvency proceedings without the requirement of creditor primarily initiating the insolvency proceedings against the corporate debtor. And this is settled law, that the bankers or the secured creditors are not required to initiate CIRP. Yes, but there is a mandatory requirement that there has to be a default by the corporate debtor before the secured creditor initiate the insolvency proceedings against the personal guarantor. But it is not mandatory, or it's not a prerequisite that CIRP has to be initiated first before moving an application under Section 95. The Supreme Court recently clarified the constitutionality of these provisions under the code, along with the extent of liability attributable to a personal guarantor under the legislation. The judgment is critical since it grants higher leverage to the creditor of the corporate debtor to retrieve the outstanding amount that was not collected through the resolution plan. By the virtue of personal guarantor's insolvency resolution process, this creates a dual safety net for a creditor to claim their dues from not just a single entity. The result of recently pronounced judgment has already high bargaining power, has given a high bargaining power to the creditors, leaving the personal guarantor with limited scope of protection under the code. This is what I said. Lalit Kumar Jain judgment was not settled, and beyond which this recent judgment of Supreme Court in the case of this Dilip versus Union of India has made the things more stronger in favor of the creditor, that personal guarantor's liability will not be discharged or will not assumed to be discharged upon approval of the plan. And nevertheless, Article 14 is not coming in way as far as provision of section 95 to 100 is concerned. So how the opportunity will be given to the personal guarantor, that is dealt with by the Supreme Court in its judgment. Secondly, what is going to be the role of RP when RP will be presenting a report before the Honorable Adjudicating Authority? That is what provided in this judgment of Supreme Court.
Sir,
let's have a look on this.
So
Yes,
this opens to wider questions, because you say under IBC, the directors or the so-called guarantors want protection, whereas they don't enjoy any protection under DRT Act, or if I file a petition under Indian Contract Act also.
correct.
So this is an act for people to escape their liability. That
Absolutely
is a very dangerous trend. That's why I raised the issue of that earlier when I said about the Jet Airways. So this opens a much wider question, sir. I agree with your point in respect of MSME. I agree that actually, when it is finally settled, there should have the protection. And also I agree with the point of that Section 140 is not built in IBC. Subrogation is not there, not referred in IBC. I agree. But there is a larger question involved. In any other act, as a creditor, I can pursue my rights in Indian Contract Act or DRT Act or even in SARFAESI Act, I can pursue. But not under IBC. Why is all this big talk and saying that there is inequality, Section Article 14, all those things?
Absolutely. When things are admittedly before you, corporate debtor has committed a default. Now the things are in. I feel that there is enormous opportunity which is already extended to the corporate debtor or to the personnel of the corporate debtor when CIRP was running. So basically, when default is established, there is no requirement to, or there is no enough room which is even required for such personal guarantor to defend their case. I agree to this. The liability of the personal guarantor is coextensive with that of the corporate debtor, as expressly provided under 128 of the Indian Contract Act. A personal guarantor's liability is established through independent contract, and the contractual terms dictate the nature and magnitude of the liability. Hence, the creditor may initiate legal proceeding against both the corporate debtor and the personal guarantor simultaneously, or they may decide to proceed in any other preferred sequence. Proceeding against the personal guarantor may be either to recover the entire amount or remaining amount. A conclusion can be drawn that once the plan is accepted by the COC, the liability of the CD comes to an end, thereby ultimately discharging the personal liability as well. This rationale, or analogized from the provisions of the ICA, does not hold valid owing to various ruling of the High Court and Supreme Court. The liability of the personal guarantors continues even if the corporate debtor is discharged. So this is what settled from Lalit Kumar Jain judgment itself. Maharashtra Electricity Board ruled applicability of 134 of the Indian Contract Act and determined that the guarantor can be sued since the debtor was released from the liability due to involuntary process of operation of law, that is insolvency, and not due to any action or inaction on the part of creditor. Correct. So that's why 134 will be supreme over 128. Hence, the court examined that the guarantor's duty under unambiguous promise persists since there is no dismissal under 134. Therefore, the personal guarantor are not automatically released from their obligation, even if the corporate debtor liability is discharged by operation of law in liquidation proceedings. It is an established legal principle that when a resolution plan for CD is approved, all liability claims, dues, and waivers or relief or exemptions for past period gets extinguished. However, the discharge is restricted to the corporate debtor itself and does not relieve the director of the company who may have acted as a personal guarantor from their obligation to make payment to the creditor as stipulated in the terms of contract. So this is how in this judgment the things have been made settled. Now, this was the judgment we were referring in Lalit Kumar also. Supreme Court in State Bank of India versus Sri Ramakrishnan held that the approval of the resolution plan under 31(1) does not automatically result in discharge of the guarantor. Instead, it may allow creditor to continue their efforts to recover the remaining gap or shortfall in the amount owed to them from the CD by pursuing against the guarantor.
Sir, underline that word recover. When many of us say that IBC is not for recovery, even Supreme Court accepts that there is a point of recovery. Otherwise, IBC has no meaning.
Recovery not against the corporate debtor, but recovery out of the, because see, recovery was not the paramount when the application was before the NCLT in CIRP. I cannot use the recovery term in that particular sense, but against the personal guarantor. If I'm moving against the personal guarantor, of course, my intent to move against the personal guarantor is to recover whatever shortfall I have accepted in the plan.
Yes. So you have to admit that IBC has the intention to recover. When many of us will say that it is very fashionable term to maximize value like that. See, as a creditor, what is that? When I lend, I expect that it has to come back.
Absolutely, absolutely.
Okay,
IBC has not given any leniency or liberty or having no sympathetic approach against the promoters. In spite of they are the MSME promoters, but they are looking all the promoter with the same eyes, and there is no flexibility which is extended to defaulting promoters. Whether to use recovery or not, that is a secondary aspect. But one thing is very clear, that personal guarantee once extended will not, or such CIRP or successful CIRP will not absolve my liability. Now, one more question which emerges here is, now that is crucial from the Companies Act viewpoint, very crucial. If I extended guarantee because I was on the board of that company when the loan was extended or credit facility was extended. But what in case if I resign from the board of the company? Even after my resignation, my guarantee which was extended at that time, that remains continuous. That remain continuous. So this is the controversy, or this is the nature of dispute which I'm facing when I'm dealing with the litigation pertaining to inter se litigation among the director. Because once I resign from the board, or once the shareholders have decided to remove me, I should not be held personally liable for the operations of the corporate debtor, which are not within my control anymore.
Sir, but
till the date you will be answered.
Nagar sir, yes, what Mr. Matthew is saying is also correct. And largely they say that IBC is for the resolution. But there are some gray shades, and since the court has given different decisions and verdicts at different point in time, situation is still fluid.
Absolutely, yes, sir.
But by and large, they say it's a resolution process.
It's a resolution process, but after the corporate debtor get resolved, they have given enough room by enacting part 3 of the code for a bank to recover their haircuts. So this is what I said, that there is no leniency or there is no more sympathy which is extended to the personal guarantor or the promoter of the corporate debtor once they have defaulted.
Yeah. And as far as this company law part which you said, the independent director who steps down from the board, and then SEBI, particularly now after even 13, 14 years, come out with something, and then by that time the director is called and asked for explanation. Probably that time that old person must have also forgotten everything.
Absolutely.
And
so
still he is asked to give explanation, and litigation starts, and that time he don't get even the protection of DNO policy of the company, because
Absolutely.
God knows that till that time the management is exist or otherwise, or company exists or otherwise.
Absolutely. And more particularly, after I step out from the board, I don't have any control over the operations of the company. So even I extended a guarantee, I may not be actually held liable for the repayment or the financial situation which is created in the company, leading to which the company has defaulted, but I have contributed nothing to that situation. So that is one of the point where I feel that even though a director is stepping out of the board because of resignation or because of the removal or even because of disqualification, but his guarantee keeps on extending till the date of repayment, up till default.
That this also reminds of the disqualification of directors. Earlier,
Absolutely.
the provision was once a company defaulted for payment of debt, interest, whatever, then that person is disqualified from being director of any company.
Absolutely.
To continue with that company, so that the person can't go ahead with any other avenue to resolve the problem.
Correct.
So, it is time and again, as I said, there is no straight jacket solution or way out for this type of situations.
Absolutely.
And circumstances differ from case to case.
Absolutely, yes, sir. So moving further, now this was in the case of Committee of Creditor of SR Steel versus Satish Kumar Gupta. So basically, many of the things have been settled by this SR matters, and many of the things are emerging out of the SR matter. The Supreme Court based its decision on Section 31(1), holding that once the plan is approved and authorized, it is binding on the corporate debtor and all the parties, including personal guarantors. However, in the present case, the plan clearly provides that the creditor's right to enforce guarantee, whether corporate or personal, would continue after the approval of the plan. In that case, a corporate guarantor or personal guarantor cannot expect any leniency. If the plan clearly provides that the creditor's right to enforce guarantee will remain intact. Aside from 31(1), the Supreme Court reasoning in this case was based on the particular terms of settlement plan. As a result of the court being vague and silent, the position whether the creditor have right to enforce guarantee after the approval of plan has been approved remain obscure. In the absence of any clarity, the guarantor's duty towards creditor may be assessed on individual facts of matter before the court. Now, this is something which is very important now. Giving finality to the unsettled position, Supreme Court in Lalit Kumar Jain held that the release of the guarantor from its responsibility is contingent upon two conditions. This is very important. The release of guarantor from its responsibility is contingent upon two conditions. One, unless the language of contract states otherwise. And that was the beginning of the session, that now that contract of guarantee or a guarantee deed will not be prepared or will not be signed with the blind eyes, unless the language of the contract states otherwise. So this is very important document which will be signing at the time of extending guarantee. So guarantee deeds will change its pattern. Secondly, if it is a result of voluntary action by the corporate debtor, such as release, discharge, composition, or modification of the guarantee agreement, the Supreme Court therein defines the line of liability of the guarantor under the code, and while dismissing the petition, declared notification dated 15th November as legally sound and legitimate. This is the extract. It is therefore clear that the sanction of the resolution plan and finality imparted to it by Section 31 does not per se operate as discharge of the guarantor's liability. However, the court has indicated the time and again that involuntary act of principal debtor leading to loss of security would not absolve a guarantor of its liability. This is what the judgment's all about. The court has indicated time and again that involuntary act of the principal debtor leading to loss of security would not absolve a guarantor of its liability. And this is what provided in former para, that release of the guarantor from its responsibility. Release of the guarantor from its responsibility is contingent upon two conditions. One is the language of the contract states otherwise. So there will be now a perusal of the guarantee deed before its execution. Up till now, which was being executed in a very hurried manner because of the disbursement of the loan, the people used to sign each and every page, even there where it is not required. But now the things will be minutely verified because there is enough room for you to rescue if the agreement provides so. So unless the language of the contract states otherwise, and secondly, if it is a result of voluntary action by the corporate debtor, such as release or discharge or composition or modification of the guarantee agreement, otherwise it is considered as 128 will not come in between. Insolvency resolution process is involuntary act, and resolution plan, if approved, is binding on all the stakeholder, and personal guarantor cannot assume or expect any benefit out of the approval of plan.
Sir, this involuntary act is taken from which act, or is it from the judgment?
Judgment.
Okay.
The constitutionality of the provisions of the code. This is Lalit Kumar. After Lalit Kumar, various petitions were filed challenging the validity of the code. More particularly, 95 to 100 of the code concerning liability of the guarantor on the grounds that room for personal guarantor to be targeted under the insolvency proceeding is extreme and inordinate. First, personal guarantors are subjected to direct insolvency proceedings. Secondly, they are not given opportunity to raise contention upon filing of application before resolution professional. Supreme Court dismissed the petitions and concluded that the role of professional is merely a facilitator and not an adjudicator. So this is what Supreme Court has mentioned. While addressing the issue, the court has made it clear that the RP is only hired by adjudicating authority based on suggestion of the IBBI. Nowadays, even it is not required because there is the panel of the IPs which are already associated with the tribunals, and tribunals used to appoint out of those panel. The sole objective of the RP is to assist in facilitative process of report preparation. So he only acts as a facilitator. We will be dealing with part 3 shortly. The court ruled that the current legislative framework does not allow for an extra adjudicatory stage, and adding such stage would mean rewriting the terms of the code. It also means clear that there are the strict guidelines for both appointing an RP and for turning it into a report. Adding an adjudicatory stage would not only slow down the process, but also make it more complicated. This is what Supreme Court has mentioned. Additionally, the court has concluded that Section 95 to 100 cannot be judged unconstitutional solely on the absence of provision allowing personal guarantor an opportunity to present their case prior to creditor filing insolvency petitions. The recent ruling represents a significant turning point as it provides reassurance regarding presence of sufficient safeguard for effective performance of resolution professional throughout the insolvency procedure. However, the protection given to personal guarantor under the code shall remain negligible. And as if they don't have enough room to challenge, because already the liability is already adjudicated. Their liability is the liability emerging out of the default of the corporate debtor. So if the corporate debtor has defaulted, there is no room for personal guarantor to defend that why they should not be held liable. And that's why this is very well provided by the Supreme Court in its judgment dated 9th November 2023 that their right is negligible. Now, there are certain key points which are unaddressed as of now. The code introduced a paradox, promising enhanced recoveries for creditor, but imposing notable changes on those standing as a guarantor. One pressing issue is the potential for multiple and concurrent insolvency proceedings. The coextensive liability of the debtor and guarantor allow the creditor to initiate simultaneous applications against both debtor as well as guarantors. This raises a concern about the jurisdictional conflict and operational challenges for NCLTs. Example, the guarantor providing a guarantee for multiple companies situated at different locations, coupled with initiation of CIRP in different cities, further underscores the complexities. So if I'm the guarantor of a corporate debtor whose CIRP is pending before NCLT Mumbai bench and NCLT Chennai, and also a corporate debtor for which I have extended a guarantee which is right now before NCLT New Delhi. So this matter is not addressed. Section 60 subsection 2 of the code mandates filing of insolvency petition against the guarantor where CIRP of the borrower is underway, creating uncertainties regarding the precedence and formulation of repayment plan across multiple proceedings. So this is something which is going to be the way ahead, or this is going to be the litigation on its way. because right now the matters are pending before the NCLT is only up to the stage of 95. Now the things will come down to section 99 where the RP will be presenting their report, and section 100 where the application will be admitted. So gradually the things will come before the way. I don't know whether the personal guarantor will be having its limitation of extending guarantee for not beyond a certain number of the corporate debtor. We never know. Rules are right now not before us. The another issue emerging in form of creditor double dipping, a practice allowing creditor to initiate simultaneous CIRP against both the debtor as well as guarantor. While NCLT expressed concern about double dipping, the coextensive liability of the guarantor and borrower, 60 subsection 2 of the code permit concurrence proceeding against both. The potential for double dipping by creditor raises question about the fairness of the insolvency process. This further calls for question of res sub judice. How is the code permitting concurrent proceedings when a proceeding on the same matter, same issue, same parties are already submitted before the tribunal? So these are the key concerns. Lastly, the extinguishment of the guarantor's right of subrogation. This is the key point. The guarantor will ended up with giving no with the guarantor will ended up with no benefit of giving guarantee. This is the issue need to be addressed upon. The extinguishment of the guarantor's right of subrogation under the code stands out as a significant issue which the court failed to address so far. Traditionally, the guarantor possesses right to step in the shoes of creditor, recovering money paid on behalf of the principal debtor. However, the court denies guarantor this right, emphasizing pro-creditor nature of insolvency regime. Denial of right of subrogation will only hinder the personal guarantor from extending guarantee owing to extremist nature of the court towards the personal guarantee. So this is what at the end in nutshell I feel are the remarkable challenges. To conclude, incorporation of the treatment of the personal guarantor into the code carries remarkable ramification for individuals who have provided personal guarantee. Personal guarantors are susceptible to the possibilities of insolvency procedure, which might result in the potential forfeiture of their personal asset, loss of commercial value of the business, and credit worthiness. The recent affirmation of the provisions of the code concerning personal guarantor is likely to elevate creditor confidence. This could lead to more assertive approach by creditor in initiating proceedings against the guarantor, fostering a sense of financial security. Additionally, the judgment may prompt caution among the promoter and individual offering guarantee, potentially leading them to be more circumspect due to highlighted risk. Even for solvent companies, in this pro-creditor environment, the personal guarantor face challenges that necessitate a careful evaluation of their financial engagement, highlighting the need for legislative and procedural clarity to ensure fair and efficient insolvency. So basically, this is nothing but a personal viewpoint of the recent judgment of the Supreme Court, that how the creditor will be having a double sword, why the personal guarantee will not be that easily available to a corporate debtor now, how the supremacy of the creditor may create a trouble, especially in those circumstances wherein a guarantor is one and has extended guarantee on behalf of multiple corporate debtor facing CIRP before multiple jurisdiction. So there are certain unaddressed issue which may basically going to take place, because very recently, today we are in the month of Feb, and just 3 months back, the Supreme Court has cleared the airs. So now such litigation will come before the Honorable Tribunal, and IBBI will surely address upon such issues which are just highlighted upon. Before we proceeding further with recent NCLAT judgment in the matter of SVA Family Trust and Ujas Energy, I would like to keep the things open for the discussion. If required, we can have a discussion before moving to the NCLAT judgment, which has made it clear that if the provision was made in the resolution plan with regards to the freeing the personal guarantors or bringing a personal guarantor's liability to to its end, to bringing the personal guarantor's liability to an end through the approval of resolution plan, then in that case a secured creditor will not be having enough room to initiate the proceeding against the personal guarantor. So we will be dealing with the NCLT Indore judgment, which was challenged before the NCLAT, and NCLAT has reversed the same, which was again preferred before the Supreme Court, and Supreme Court has upheld the validity of the judgment or upheld the order which was passed by the NCLT. But before that, if any things are required to be discussed upon, let us have a discussion. Would like to take a break of 10 minutes before moving with the next judgment of NCLAT.
Okay, sir, we'll break.
We'll have a break of 10 minutes. We will be dealing with the next of the discussion by 4:05 or 4:10. Shall we proceed?
Yes, sir.
Now, this is something which is again a very interesting judgment or ruling of the anklet. And this is arising out of the challenge which was made before the Honorable NCLT New Delhi against the order which was passed by the NCLT Indore bench. So here one of the secured creditor who has not consented to resolution plan was the Bank of Baroda. But that is something which is interesting. And this is what my understanding is, that if we can draft a resolution plan in a manner which immunes or which protect the interest of the personal guarantor, and if such plan gets approval of the COC and subsequently by the adjudicating authority, by this way you can minimize, or by this way you can immune from the action against the personal guarantor. So this is one of the interesting case. And I can say one thing, that this order of the anklet, this ruling of the anklet is upheld by the Supreme Court of India. So meaning thereby the constitutional validity as far as 95 to 100 has nothing to do with, or Lalit Kumar judgment has nothing to do with this particular ruling of the anklet, which is passed in the matter of SVA Family Trust, who is a successful resolution applicant, versus Ujas Energy Limited. Let's have a look on this part. Now, this is the Supreme Court's judgment in Lalit Kumar Jain versus Union of India, made the things clear that the resolution of the corporate debtor under IBC does not automatically discharge the guarantor of the corporate debt. This is something which is settled up till this extent. The resolution plan often states that while approving the plan would extinguish the creditor's claim against the corporate debtor, but creditor claim against the corporate debtor, it would not prevent creditor from pursuing their claim against the promoter and the guarantor of the corporate debt. A recent judgment of the NCLT principal bench considered the converse issue. Can a resolution plan provide for release of personal guarantor when a personal guarantor has not subject to insolvency resolution process? This is the issue which was dealt by the anklet in this matter. That can a resolution plan provide for release of the guarantor when personal guarantor has not subject to insolvency resolution process? SVA Family Trust and others versus Ujas Energy. The resolution plan proposed by SVA Family Trust provided for total payment of approximately 75 crores to settle the creditor dues, out of which approximately 24 crore was earmarked as a consideration for release of the personal guarantee issued by the promoter of the corporate debtor. So out of the 75 crore resolution amount, 24 crore was earmarked, or it was basically accommodated towards release of the personal guarantee issued by the promoter. Plan has been approved with the consent of 78.4% of the financial creditor, but one of the financial creditor, that is Bank of Baroda, has objected the plan, contending that the plan for a corporate debtor could not take away the right of creditor to proceed against the personal guarantor. NCLT Indore bench also rejected the plan on the grounds that plan could not provide for release of personal guarantee. Of course, the anklet, or the NCLT Indore bench has passed an order based on Lalit Kumar and based on this recent Supreme Court judgment. NCLT reversed the decision of NCLT, holding that it was well within the commercial wisdom of the COC to approve a plan that provide for release of personal guarantee. And I think there is no contrary view also. NCLT acknowledged that there had been cases such as Supreme Court decision in Lalit Kumar Jain, which made that clear that resolution of the CD shall not per se resolve or discharge the personal guarantor from its liability. However, this judgment does not imply that resolution plan could never provide release of personal guarantor. So this is something which is quite settled that if my plan propose release of personal guarantor liability, and if it is accorded or if it is consented by the COC, then it will not go against the personal guarantor, or liability of personal guarantor will come to an end with the liability of the corporate debtor. There is no contrary judgment. There is no contrary views also. Enclad, but this is something which is pertinent to note that Enclad differentiated this case from its prior judgment in Nitin Chandrakant Nayak versus Sanitya Industries LLP, where the tribunal had held that a resolution plan could not consume the asset of personal guarantor without recourse to appropriate proceedings. Now, this is the Enclad judgment, the earlier Enclad judgment in the matter of Nitin Chandrakant Nayak versus Sanidhi Industries LLP, whereas the tribunal has held that the resolution plan could not consume the asset of the personal guarantor without recourse to appropriate proceedings. The resolution plan in Ujas Energy, the NCLAT pointed out, did not deal with the asset of the personal guarantor, but only provided for release of personal guarantee. So this is the ratio which is provided that had been granted as a security for financial assistance provided to the CD. Finally, Enclad emphasized that minutes of the COC meeting clearly reflected that the release of personal guarantee had been discussed at length, was a deliberate discussion or decision of the COC, given that COC had clearly applied its mind in agreeing to release of the personal guarantee in consideration of a specific amount. Enclad found no reasons to question its exercise of commercial wisdom. The COC indeed granted significant discretion in exercising commercial wisdom, a point that has been widely accepted by the court and tribunal, particularly after Supreme Court judgment of SR. It is also the case that IBC provides for a wide range of action that may be taken through resolution plan. 31 standing that the plan are binding on all stakeholders, including guarantor. However, the Enclad judgment in Ujas Energy nevertheless raises a critical question of whether a plan can extinguish the right of creditor to proceed against the party other than the corporate debtor. Though the corporate insolvency resolution process, individual creditor give up their right to take separate enforcement action and are bound by the decision of the COC. For example, if the COC by voting share of 66% approve the plan that provide for 80% haircut for financial creditor, the dissenting financial creditor would have to accept the plan. As long as they receive at least liquidation value of their claim, the right of dissenting creditor to proceed against the corporate debtor get extinguished by the virtue of approval of resolution plan. So this is what I said. Now the plan will be proposed in a manner which can safeguard the interest of the personal guarantor. But this is going to come only when if the plans are being proposed by the MSME promoter, because no resolution applicant, outsider applicant, or no investor who is bringing a resolution plan will be interested in securing the interest of the personal guarantor of the corporate debtor. However, the case of Ujas Energy differs from typical scenario because the liability under the guarantee is not a debt owned by the corporate debtor. Instead, the guarantee is a debt of third party, often are the promoter of the CD, created through a contract of guarantee between a creditor and third party. The creditor who is a beneficiary of the guarantee may of course waive its right to claim under the guarantee, but can this be extinguished without individual creditor's consent through COC? Now, this was the moot question. The IBC explicitly clarifies that CIRP only relates to CD and its asset, and as a consequences, the right of creditor vis-a-vis corporate debtor. Given this is questionable if the decision of the COC can take away the creditor's right to debt owed not by the corporate debtor but by a guarantor. Further, while agreeing that a resolution plan cannot deal with guarantor's asset, Enclad judgment failed to consider whether resolving a personal guarantor's debt without taking into account the personal guarantor asset violate the creditor right in the broader borrowing arrangement. So I think this is something which I can say having dual views, but I feel that as far as the resolution plan is concerned, the resolution plan, let's have it the judgment with us. I'm just sharing the copy of judgment of Ujas Energy, and that is something which is going to be helpful. Now this is judgment of Ujas Energy. Let us have it the operative part before us. This is something which is relevant. The expression per se or ipso facto clearly indicates that by approval of plan, the personal guarantors are not per se or ipso facto discharged from its obligation, which may arise of guarantee given to the financial creditor. The use of above expression conversely indicates that there may be a situation and circumstances, for example, relevant clause in the plan by which a personal guarantor may be discharged. The judgment of Honorable Supreme Court in Lalit Kumar case cannot be read to mean as laying down the law that a personal guarantee never be discharged in resolution plan. So this was the say of the successful resolution applicant, that the judgment which is settled by Supreme Court in Lalit Kumar case, that cannot be read to mean as laying down a law that personal guarantee can never be discharged in plan, meaning thereby that was the say of the successful resolution applicant. Counsel for Bank of Baroda submits that a moratorium is not applicable on personal guarantor and their assets cannot be a part of CIRP. Judgment which has been relied by the learned counsel in State Bank of India versus Ramakrishnan, the Supreme Court in paragraph of the said judgment following was held, section 31 of the act was also strongly relied upon by the respondents. Section only states that when a plan is approved by the committee of creditor takes effect, it shall be binding on the corporate debtor as well as the guarantor. This is for the reason that otherwise under 133 of the Indian Contract Act, any change made to the debt owned by a corporate debtor without surety's consent would relieve the guarantor from payment. Section 31(1) in fact make it clear that guarantor cannot escape payment as planned, which has been approved may well include provision as to payment by the guarantor. This is perhaps the reason that require information as personal guarantee that have been given in relation to the debt of the corporate debtor. Far from supporting the stand of respondent, it is clear that Section 31 is one more factor in favor of the personal guarantor having to pay for debt due without any moratorium applying to save him. We are also of the opinion that Section 96 and 101, when contrasted with Section 14, would show that Section 14 cannot possibly apply to personal guarantor, which was a ground of challenge before the Supreme Court. When an application is filed under Part 3, an interim moratorium is applicable in respect of any debt due. First and foremost, this is separate moratorium applicable separately in case of personal guarantor against whom insolvency resolution process may be initiated under Part 3. Secondly, the protection of moratorium under this section is far greater than Section 14 in that pending legal proceeding in respect of debt and not the debtor estate. The difference of language between 14 and 101 is for a reason. Section 14 refers only to debt due by the corporate debtor who are limited liability companies, and it is clear that in the vast majority of the cases, the personal guarantees are given by the director who are managing the companies. The object of the code is not to allow such guarantor to escape from independent and coextensive liability to pay off the entire outstanding debt, which is why Section 14 is not applicable, which the Bank of Baroda has taken. There can be no dispute that moratorium under 14 is not applicable on personal guarantor. Non-applicability of moratorium on personal guarantor is with different object and purpose. Personal guarantors are liable along with the principal borrower and can be proceeded with for recovery of dues by FC. But question as to whether a personal guarantee given to FC can be extinguished in plan is a question which is separate question and was not under consideration by Supreme Court in State Bank case. Learned Counsel for the Bank of Baroda has reliance upon the judgment of Nitin Chandranayak Nayak. So that was a prior judgment of NCLED. Nitin Chandrakant Nayak and other versus Sanidhya Industries. Reliance has been placed in para 21 and 24 of the judgment, which are as follows. The Supreme Court observed that Section 31 is one more factor in favor of the fact that a personal guarantor is required to pay for the debt without any moratorium applying to save him. What is clear is that Section 31 does not absolve the personal guarantor from liability. But then the respondents are trying to rely on para 22 of the judgment of Supreme Court to say that in resolution plan itself, there can be a provision to move against the personal guarantor. We do not agree with this submission. It appears resolution plan can have a jurisdiction as to right of payment to be received from guarantor. To us, it does not appear that a judgment lays down in the resolution plan of a debtor itself provision could be made to consume property of the personal guarantor without recourse of appropriate. So that was with regards to property of the corporate of the personal guarantor without recourse to appropriate proceeding, which were earlier as per act than applicable part 3. Before part 3 was enforced against the personal guarantor, the provision under which one could move against the guarantor are mentioned by Supreme Court in para 15 of the judgment in Ramakrishnan. After coming into force of part 3, now one would have to proceed against part 3. If the argument of the respondent were to be accepted, then there would have been no need for the earlier provision being amended. After part 3 is enforced, there would be no need of part 3 if the property of the personal guarantor could be simply included in the resolution plan and disposed directing them. So the question in the in this judgment of NCLT was whether the asset of the personal guarantor can be included in resolution plan and not pertaining to the question whether the liability of the personal guarantor comes to an end by approval of plan or not. So that was a difference between the judgment which was passed by Honorable NCLT in Nitin Chandrakant Nayak and the judgment which was passed in Ujas Energy. Going back to the judgment in the matter of State Bank of India and Ramakrishnan, if moratorium under 14 of the code during CIRP does not apply to guarantor, the personal property of the corporate debtor cannot be released by sale or transfer in the CIRP of the CD without resorting to proceeding before appropriate authority. So this was the argument and counter argument. What has been laid down by the tribunal in the above case is that in a resolution plan, the property of the guarantor cannot be consumed without recourse to appropriate proceeding. And that is part 3 of the code. The present is not a case where any property of the guarantor are being consumed and dealt within a plan. The present is a case where the FC has declined to relinquish personal guarantee given to secured financial assistance granted to CD by the FC on payment of a particular value of the plan. Judgment of the tribunal in Nitin Chandrakant Nayak does not help the Council of Bank of Baroda. So this is why the NCLT has taken different views from its earlier view with regards to Nitin Chandrakant Nayak matter. Learned Counsel for the appellant has relied on the judgment of Honorable Supreme Court in Karad Urban Cooperative Bank Limited versus Swapnil. So in that case, the Supreme Court, after referring to its judgment, K. Shashidhar versus Indian Overseas Bank, SR Steel, the principle laid down in the aforesaid decision make one thing very clear. if all the factors that need to be taken into account for determining whether or not the corporate debtor can kept running as a going concern have been placed before the committee of creditor, and COC has taken a conscious decision to approve the plan, then adjudicating authority will have to switch over to the hands of mode. It is not the case of the corporate debtor or the promoter or director or anyone else that some one of the factors which are crucial for taking a decision regarding the viability and feasibility were not placed before the COC. The only basis the corporate debtor to raise the issue of viability and feasibility is that the ownership and possession of the ethanol plant and machinery is the subject matter of another dispute. So it is again, they are emphasizing upon the paramount power of the COC or supremacy of the COC to take such decision. Present is the case where it has been categorically pleaded that the issue of release of personal guarantee were deliberated. This is the again judgment of Ujas Energy. The present is the case where it has been categorically pleaded that the issue of release of personal guarantee was deliberated by COC in its meeting. In 13th meeting, while considering the plan under agenda number X, the objection of counsel for Union Bank of India was noticed. The issue of release of personal guarantee was very much in discussion before the COC, which is clear from the minutes of meeting of the COC, which minutes record the following while deliberating. The COC requested Mr. Mundra to consider segregating the amount allocated towards payment to FC between that payable against the personal guarantee and collateral security on one hand and against the fund-based liability on other, which will facilitate a better comparison. Mr. Mundra told COC that such segregation may be difficult, but assured to give the matter a serious consideration. So here the matter was the release of the personal guarantee was very well discussed and deliberated. And in consideration of release of the personal guarantee, the successful resolution applicant has already appropriated certain amount in favor of that secured financial creditor who objected to the approval of resolution plan. The present is the case where COC consciously considered the clauses in the plan for relinquishing the personal guarantee of financial creditor, and as noticed above for consideration offered by successful applicant for release of the personal guarantee passed in the plan, accepting the clause in the plan for release of personal guarantee. Learned counsel for the Bank of Baroda, that is the dissenting financial creditor, has relied upon M.K. Rajgopalan versus Dr. Pariswamy Palani. So this is judgment which is of Honorable Supreme Court, has upheld the order of appellate tribunal holding that plan is in contravention of the provision of law. Honorable Supreme Court in para 184-189 laid down that in the given set of facts and circumstances of this case, appellate tribunal has rightly held that resolution plan being in contravention of the provision of law for the timing in force. Observations and finding of the appellate tribunal. I think we should deal with the operating part. The present is not a case where issue pertaining to the release of personal guarantee was not before the COC and was not deliberated. So it was very well accepted by the COC in its meeting. As noticed above, there was a specific clause in the plan pertaining to the release of personal guarantee, which clause was deliberated. Even the objection raised by Union Bank of India that a personal guarantee cannot be released was noticed. It is useful to extract the objection anyways, and there was no error in consideration of COC of the resolution plan, and commercial wisdom of the COC by approving the plan has to be given a due weightage. The judgment of Edelweiss Asset Reconstruction and Anuj Jain. In the above, the financial creditor of the corporate debtor aggrieved by the approval of plan has filed the appeal. The grievance of the appellant was that the appellant had security interest in the land of the CD, which has proposed to be sold in the plan. The submission of the appellant was negated by the tribunal, and it was held that such security interest by corporate debtor could have been very well dealt in the plan. So this is something which was relied upon. The above judgment fully supports the submission of the appellant that security interest of dissenting financial creditor by virtue of personal guarantee of ex-director could have been very well dealt in the plan. It is further relevant to notice that each financial creditor has a personal guarantee in their favor to secure the loan extended by them. All financial creditor has assented for relinquishment of the security except BOB, which has only 5.83% voting share. The decision of the COC to accept the value for relinquishment of personal guarantee was the commercial wisdom of the COC, which cannot be allowed to be impugned at the instant of dissenting financial creditor. In view of the foregoing discussion, we are of the view that the adjudicating authority committed error, that is NCLT Indore bench, in rejecting the application for approval of plan on the ground that plan could not have contained a provision for extinguishment of guarantee. Plan allocated a plan value for extinguishment of personal guarantee, which has been accepted by the financial creditors with a voting share of 78%. We thus are of the view that the order of the adjudicating authority dated 6 Jan 23 is unsustainable. In result, we allow the appeal and set aside the order dated 6 Jan 23 passed by NCLT Indore. We hold that plan submitted by the appellant did not contravene any of the provision of 32E of the code. The adjudicating authority shall proceed to pass a fresh order praying for approval of the plan along with necessary direction. Adjudicating authority shall endeavor to pass a fresh order within a time span of 3 months. So basically, this NCLT and this NCLAT judgment thereafter has made the things clear that until the resolution plan is not dealing with the asset of the personal guarantor, it does not come in way of NCLT or NCLAT, and the liability of personal guarantor can be extinguished. Upon approval of the resolution plan of the corporate debtor, the liability of the personal guarantor can also comes to an end if it is assented by the financial creditor. I said, now this is going to be the proposal of every MSME promoter proposing a plan, but we are not sure how much an independent resolution applicant or independent investor proposing a resolution plan would be interested in safeguarding the interest of the personal guarantor. But if it is the case, if an independent resolution applicant is interested in safeguarding the interest of the personal guarantor, and if it is accepted and agreed upon by the COC, then this enclave judgment is going to be the foundation on the basis of which several personal guarantor will take the benefit of getting out of their guarantee or out of the liability arising out of their guarantee. So basically, Lalit Kumar Jain, thereafter, a matter of Dilip versus Union of India, which was passed on 9th of November 2023. And thereafter, this enclave judgment has made one thing very clear, that personal guarantor will nowhere be safeguarded by the virtue of approval of resolution plan. And the only way and the only means through which their interest can be safeguarded or their interest can be protected is through the approval of the resolution plan. But contrary, resolution plan cannot deal with the asset of the personal guarantor. It only going to deal with the asset of the corporate debtor, which is under CIRP. So these are the two judgments which need to be taken into consideration while proposing any resolution plan. One is the NCLAT judgment, this judgment of Ujas Energy. This judgment of Ujas Energy, this is Appeal 266 of 2023. This is one of the judgment, and while dealing with the judgment, it is very important to oversee the judgment which was passed by NCLT in the matter of Chandrakant Naik matter. Because in earlier matter, it dealt with the matter pertaining to the asset of the personal guarantor, whereas this particular case, the asset of the personal guarantor is not the question. The question is whether the liability of personal guarantor can be dealt while approving a resolution plan or not. So in that circumstances, this particular judgment will prevail. So Nitin Chandrakant Nayak versus Sanidhya Industries and LLP versus SVF Family Welfare Trust and Ujas Energy are going to be the key document while proposing any resolution plan for the approval of the COC. And what need to be taken care of is what is provided in this judgment. So by this judgment, one thing is very clear, that resolution plan can safeguard the interest of the personal guarantor, or else the deed of guarantee which was executed by the promoter or the personal guarantor at the time of extents, at the time when loan was granted to the corporate debtor, the language of the contract may otherwise safeguard the interest of personal guarantor. Otherwise, by this two judgment of Lalit Kumar and the last judgment of Supreme Court, the liability of personal guarantor will always be at stake, and the action will be initiated by the creditor for the recovery of all the haircuts which they have accepted while approving resolution plan. Yes, sir.
The issue is more for more litigation. That's what I understand.
Litigation is going to be at pace now once the personal guarantor's application will reaches to section 100. So once the application will be admitted, more and more litigation will coming on way before the adjudicating authority.
Sir, I think with various NCLATs, NCLTs proclaiming various decisions, and not only this issue, the IBC thing has become very complicated and more of a legal matter and less of resolution matter.
And leading to this legalities or the disputes, the resolutions are being postponed.
Actually, what I'm telling. So I would like to make a comparison with this act as well as the SARFAESI Act. In SARFAESI, there are no courts except for DRT having a limited jurisdiction. It is the authorized officer who carries on whatever is the recovery. But now you see that parallel to an authorized officer, there is an IP, but he is virtually powerless. And he is at the mercy of a lot of legal entanglements and all those things. That's very sad.
Absolutely, yes, sir. So there is a question, personal guarantor's application to be filed before which adjudicating authority? It is the NCLT only. Section 60 subsection 2 has made it very clear that before the bench where the CIRP or liquidation proceedings of the corporate debtor is being dealt with, is being adjudicated, there is the only bench where the personal guarantor application will be made before the creditors.
Yeah, but sir, there is an issue. If a creditor choose to pursue IBC before CIRP, then it is to be filed in DRT.
If he choose to pursue, but again, as far as this personal guarantee is concerned, as far as an application against the personal guarantor is concerned, nowhere DRT is going to be the jurisdiction. This is what we said in section 60.
Okay. Okay.
I'm just sharing it for convenience again.
Okay.
Is it visible?
Yes, it is.
So as far as this section 60 is concerned, section 60 subsection 2 is very clear that without prejudice to subsection 1, and when we see subsection 1, the adjudicating authority in relation to insolvency resolution and liquidation for corporate person, including corporate debtor and a personal guarantor, shall be the NCLT having territorial jurisdiction over the place where the registered office of the CD is located. This is one. Adjudicating authority in relation to insolvency resolution and liquidation of corporate person, including corporate debtor and personal guarantor, shall be the NCLT having territorial jurisdiction over the place where the registered office of the corporate person is located. Yeah, subsection 2, without prejudice to 1, and notwithstanding anything to the contrary contained in this code, where corporate insolvency resolution process or liquidation proceeding of the corporate debtor is pending before the NCLT, an application relating to insolvency resolution or a liquidation or a bankruptcy of the corporate guarantor or a personal guarantor, as the case may be, of such corporate debtor shall be filed before such NCLT. If it is pending, then it will be before such NCLT. And even if it is not, then in that case, subsection 1 make it clear that insolvency resolution and liquidation for corporate person, including corporate debtor and guarantor, shall be NCLT having territorial jurisdiction over the place where registral office of the CD is concerned. But now the point of concern is, if I'm the guarantor to 3 corporate debtor, all 3 corporate debtor are having a registral office which falling under a separate NCLT jurisdiction, then this is going to be a point which required to be clarified upon or to address upon.
No, in today's video mode appearances, there should not be a problem.
So problem is not with regards to appearance. The problem is with regards to collating of the claims of that creditor.
Yeah, but they are separate CIRP, sir.
They are separate CIRP. I am the one who is
the
common for
director.
the CIRP.
Common director. Okay.
I am the one who is common for all the corporate debtor.
Yeah, okay. No issue. Today's digital age, there should be a solution through that.
And there will be 3 separate bench of NCLT who is going to hear with regards to an application against me. And all 3 benches of NCLT will be having different views pertaining to the application which is pending against me.
Yeah, that could possible, sir. Possible. Possible.
Asset will be attached with which petition?
Sir, I think the voice is breaking, sir. You're not audible. May I have your view, sir?
Rejoin.
So any further questions to be addressed upon, I can take those questions first. Everyone do have multiple questions because the code itself making it very much ambiguous as far as the liability of the guarantor in spite of the complete discharge of the liability of the corporate debtor. So, and I feel that this is going to be a never-ending litigation until there is a settled law. Presently, the law is being settled through Supreme Court judgments. And yes, the judgment of Supreme Court itself make the law very clear. But at present, the things are not in line with the requirement or in line with the Indian Contract Act, which talks about release of the liability when the liability of the principal debtor comes to an end. So in this regard, I think there will be a lot of development which we may anticipate in this code with regards to part 3. Presently, the part 3 is only activated or only enacted for the personal guarantor, and till date, the insolvency resolution process for individual or partnership firm or proprietorship concerns are not yet dealt under the IBC. So that is going to bring a new area of discussion for all the stakeholders. Any questions or any concerns or any opinions or any discussions? If any of the participants are willing to have, we can take the benefit of that ideas or that discussions. It's always a pleasure on my part to be a part of this all the intellectuals. Yes, sir. Yes, ma'am.
It means that whenever any resolution process IRP is to be initiated against a personal guarantor, if CIRP is going on, then it will be with the bench which is considering the CIRP.
Yeah, it is before the bench which is adjudicating the application against the CD.
If there is no CIRP going on, or
If there is
action
no
is to be
CIRP
initiated
going
after the
on,
CIRP is over.
so in that circumstances, the creditor will move an application before that relevant bench where the corporate debtor, registered office of that corporate debtor on whose behalf the guarantee was extended by me, false. So basically,
It
suppose if
is
CI, yes,
okay. So no role of DRT is here as far as personal guarantor is
by
concerned.
virtue of 60 subsection 1 and 2, no.
Okay. Thank you. Thank you, sir.
Thank you, ma'am. Anjali ma'am, can we sign out now? Can we conclude the session? Or still in
एक मिनट
case?
विनीत सर, एक बात बता, आई जस्ट वांट टू नो, जब CIRP गोइंग ऑन बिफोर एन NCLT है तो वो भी तो उसी NCLT बेंच के वहां पे होगी ना जहाँ पे रजिस्टर्ड ऑफिस सिचुएटेड है,
करेक्ट।
तो
वही
फिर ये दो डिफरेंस क्यों दिए हुए हैं इसमें?
नहीं, कोई देयर इज नो डिफरेंस मैम। इसमें बहुत ही क्लियरली ये चीज मेंशन कही है। आप जब सेक्शन 60 सबसेक्शन 1 में पढ़ेंगे तो वही लिखा हुआ है, adjudicating authority in relation to the insolvency resolution and liquidation for corporate person, including corporate debtor and personal guarantor, shall be the NCLT having territorial jurisdiction over the place where registered office of the CD is or corporate person is located.
तो बोथ द केसेस बात तो सेम ही कह रहे हैं ना ये कि
हाँ, बात यहाँ पे पहले क्या था, it was only limited to the corporate debtor, but after that 2018 amendment they have also made it clear that even though the jurisdiction for individual and partnership firm and proprietorship is DRT and appellate jurisdiction is DRAT, but for a personal guarantor it is going to be the NCLT only, where the CIRP is being adjudicated upon by the NCLT. So for personal guarantor, they have made it clear that it will not go with the individual or proprietor or partnership firm. The jurisdiction will stay with the NCLT, and more particularly that NCLT which has dealt with or dealing with the CIRP of the corporate debt.
okay. Okay, sir. Thank you. Thank
Yeah.
you.
This is my last query, not related to what we are debated. Why is that the government is not implementing or notifying the implementation for sole proprietorship and partnership?
What I feel is because the implementation with regards to the personal guarantee or personal guarantor is still not dealt with by the RPs or by the NCLT at this moment. Very recently, the NCLT has made the things clear that constitutional validity of 95 to section 100 was challenged, and it was made clear by the Supreme Court that these are constitutional only, and there is no question pertaining to their unconstitutionality. So at this moment, I must say that government must be eyeing upon that how the process, the insolvency resolution process or approval of the repayment plan or bankruptcy process of personal guarantor will be dealt with. What practical difficulty they are going to face during the approval of the repayment plan of the personal guarantor or bankruptcy process of the personal guarantor, and probably the next immediate step which the government must be eyeing upon is to make part 3 effective for individual as well as partnership firms. They might be waiting for checking what the teething problem this NCLTs or this law is going to face with regards to insolvency of resolution or insolvency resolution process of personal guarantors. So that is probably, otherwise there is no reason why part 3 is not enacted for sole proprietorship or partnership firm or individuals.
Okay.
But I think that is going to be one of the very that is going to be one of the big challenge which the government is going to face, because as far as the personal guarantor is concerned or the corporate debtors are concerned, the stakes are very high. The stakes are high, the secured creditors are involved. But in case of an individual or partnership firm, I think in that circumstances, because one thing which I feel, when a secured creditor initiate an action against the personal guarantor by opting for part 3 of the code, the moratorium comes to the moratorium or the interim moratorium begins the moment applications get made. In that circumstances, just because of the interim moratorium or moratorium, they don't have that liberty to take the recourse under that SARFAESI, which otherwise they are having. And I think for recovery, for the aim of recovery from this individual or partnership firm, the SARFAESI will be the first option they are going to opt for. But just by moving an application under part 3, under section 95, they themselves are admitting that because of the interim moratorium or moratorium, they will not be in a position to go against the individual or partnership firm by taking the benefit of SARFAESI. So I think that bank will be more interested in invoking their rights under SARFAESI rather than moving an application under part 3 of the code.
Of course, sir, because in SARFAESI there are no codes, enclaves or nothing.
Yes.
That's
Second benefit is, in SARFAESI, I am only supposed to deal with my interest, and there is nothing like COC which will come in between. But in this,
exactly.
That's right.
Sir, what will happen to law of subrogation now?
that is hanging questions, because if I'm and you are the guarantor, we will be least interested in giving guarantee if we don't have any right of acting as a guarantor. And that is an unsettled question which is not dealt by Supreme Court, neither in Lalit Kumar matter, neither in this last matter of Jivraj Ka. So I am with you in this case, because if right of subrogation is not dealt with, you need to buy or you need to search for a guarantor at a very heavy cost. Because at the end, guarantor will not get its right even after discharging the liability on behalf of the corporate debtor. Absolutely, yes.
Basically, this is the directors who are taking guarantee are basically promoted directors. Banks or FIs don't take the guarantee of professional directors or independent directors. So what is now going to happen is that promoter director will still be responsible. That, of course, continues, notwithstanding the fact that the issue of Section 140 is addressed or not.
Absolutely, yes. But now the question is, Mr. Kapadia, sir, what he basically raised the point is that right of subrogation, if I'm extending my guarantee and still I'm not getting right as a guarantor, what about my right as a guarantor, even if I dealt with the liability of the corporate debtor?
So, yes, Mathur sir, what you said is right, that in most of the cases, the promoters are the guarantor, but not necessary. Sometimes, the other directors also, tend to give kind of a comfort to the lender and extend their guarantee, thinking that, they have a right of subrogation. So, in that case, the other guarantor, other than the promoter, they have to simply submit their right of subrogation at stake.
I agree with you, Kapadia, sir. But I would say as a banker, as bankers and FIs normally don't take professional as well as independent directors. Independent directors are regulated by some other laws also. You remember that into the corporate governance also. So we are the bankers are off from independent as well as professional directors. It is basically the promoted directors who normally subscribe to the bank guarantee.
Right. No, what happens sometimes when the promoter do not have any asset base or something which satisfy the collateral to the lender. In that case, some more particularly cooperative bank, they always insist for kind of either a guarantee of from any person who has got the asset base or some kind of a collateral security. In such cases, the guarantor always think of, yes, this company, if something happens to me, there is a right of subrogation and I will enter into the suit. Okay, there may be some kind of a haircut he is ready to take it. But when the entire question of subrogation itself will go away, in that case, it's like, the 100% stake of the guarantor will be, it is to be forgotten. So Vinit sir rightly said that if such kind of a situation, probably the promoter or such kind of a company may have to provide a very high cost for this kind of a guarantee.
Yes, I agree. It could.
So it is deterrent to the growth of the country actually. So Vinit sir, anyway, very nice presentation and very lively you have taken up this session. May I suggest or may I request if you can share your email ID and would like to have your PPT because it needs little more detailed study. If you can provide us, it would be very great.
We'll be sharing the same, sir. So basically the content is taken out of the basically the viewpoints of several authors. So basically it is not my own content, but it was the viewpoint of multiple authors and practitioners who are dealing into this bankruptcy law. But I will share the compilation, which in any ways is not belonging to me. It is a property of
nicely compiled, and so it's very useful to have a straight reading instead of going through various cases one by one.
We'll be sharing the same, sir.
Yeah. Thank you very much. Thank you.
Thanks a lot, sir. Thank you,
sir.
Thank you for a very nice session. Thank you.
Thank you. Thank you, sir. Thank you.